Hello and welcome to the debate. I'm your host Sana Maqbool with you at BTV World. In today's show, we're going to be talking about the very important decision that has been taken by the Supreme Court that has upheld the Supreme Court Practice and Procedure Act. This is important, especially given the number of times that we have discussed this issue and the scale at which this was, of course, being done. What is being called unprecedented, not just in terms of this particular decision being taken, but also the way that it has been taken with a full court bench in place, with the proceedings also being in camera, and of course the new Chief Justice of Pakistan taking on board different judges with regards to curtailing his own powers. So this is going to be, of course, an important way forward that we're going to see, but the impact, of course, of this decision is important as well, especially in terms of the kind of feedback that a lot of people, of course, are giving. Most, of course, are talking about how this is a remarkable decision taken and shows the transparency of the Supreme Court, and also talks about the way that the matter has actually been dealt with. Others have also pointed out some concerns with regards to the way that the Parliament can possibly legislate in the future or intervene in the matters of the judiciary, especially, of course, regarding matters of concern and other powers also. There is also, of course, concern with reference to whether or not this is going to have political impact on various decisions, with the issue of the return of Mr. Nawaz Sharif and his role in active politics also being discussed. However, of course, as we know, as part of the decision taken, he will not be able to appeal the Supreme Court decision, but there is, of course, going to be an interesting scenario with regards to his disqualification and the time span for which whether or not there is going to be a legal procedure that is going to be carried forward with regards to the interpretation of the article that limits disqualification, the amendment that limits disqualification to 5 years. So we're going to be taking a look at this both in terms of the most immediate impact that it's going to have, and then long term also, and whether or not these considerations then have been taken as part of this decision. At the end of the show, we're also going to be talking about the political dynamics of the country, especially in the way that they will be impacted with the return of the PMLN leader, Mr. Nawaz Sharif, scheduled about 10 days from today. And there is, of course, a lot of hue and cry about how PMLN is preparing for his great return, and the way that this is going to affect the political domain of the country. Of course, legalities aside, the way that Mr. Nawaz Sharif's presence in Pakistan after a long time span will impact the current situation, given the upcoming general elections as well, is going to be interesting, and what sort of role he's going to be playing in this regard, especially in light of today's decision, will be under discussion. For this and more, of course, as always, I've been joined in the studios by senior analyst Farrukh Pitafi. We've also been joined in the studio by legal expert Barrister Yasser latif Hamdani. Thank you very much, Barrister, for being part of the discussion. And we've also been joined online by Barrister Shabbir Ahmed, Advocate, Supreme Court. Thank you very much, Barrister, for being part of the discussion as well. Let me start with you, Barrister Yasser. Given, of course, today's verdict and the decision that has been taken, this, of course, has a huge impact, and there is, of course, a lot of opinions coming forward as to what sort of should have been done, and what sort of action the Supreme Court has taken. First, your views on this.
I think it's a historic occasion for Pakistan. What we've seen happen is that, first of all, the Supreme Court has unequivocally upheld the idea of parliamentary sovereignty. So this was a long time coming, but I think today we've taken that very crucial step towards that all important situation where the elected institutions are at some level at par with the unelected institutions in Pakistan. So I think that's big. I think with respect to the democratization of the Supreme Court, I think that is the most important thing that has come out. This has been a perennial problem for the Supreme Court and for Supreme Courts all around the world, for that matter. They've had this issue of bench fixation, of where there is suo motu power, when to take it, who is to decide when to take it. All of these things now have been given to a collegium. And that collegium now democratizes the Supreme Court in the sense that now you have three judges, three senior most judges sitting together and deciding, you know, what benches should be constituted, or what public importance issues of public importance merit taking the suo moto on. So I think that is a huge step forward for Pakistan. I think in terms of, because this was, and the fact of the matter is that this has been done voluntarily in a way. In a way, one could argue that the Chief Justice has given away his powers, you know. But I think a lot of reasonable, and over the last 1 year or so, we've seen judgments, dissenting notes coming out of the Supreme Court, which have emphasized that this should happen, that there should be an end to the unfettered discretion that is vested in the Chief Justice. And then the Parliament ultimately had to take action, and the Parliament did, and the fact that it was upheld by the Supreme Court, this is the most important part. The Supreme Court held, and the judges that are in the majority by and large believed, and they said so in court, those of us who attended the court hearings, that the Parliament, when it decides, its will should be respected by other institutions, especially institutions which are not elected. You see, the main argument that came out from the bench, and this was very positive. There were people on the bench who said, like Justice Mansoor Ali Shah and Justice Athar Minallah, who said that if the Parliament does it, it should be acceptable. If it's the unelected judges who do it, that is something that should be questionable. Therefore, they laid that principle, that idea that Parliament has that sovereignty. And I think with this going forward, I think Pakistan, I as a student of Pakistan's political science, as it were, or history, or I am very, very, I think this is a red letter day for all Pakistanis who want to see Pakistan become a democratic state, a civilian-led democratic state, where the chosen representatives of the people decide the course of action for the future, the destiny of the people of Pakistan.
Right. Barrister Shabbir, I'd like your opinion on the matter as well, and whether or not, when we talk about this question of whether the Parliament can actually intervene in the matters of the judiciary, it seems that there are also opinions in the aftermath of this decision talking about how this may actually be misused by powers both within and outside of the Parliament potentially in the future, and can also sort of open up gates that perhaps the judiciary does not want in the future. Do you think that could be the case?
I think I would straight away agree with my learned colleague that it is a fantastic day for Pakistan. You have seen that in your program and in so many others, I've been criticizing the Supreme Court the most, primarily in the last 1 year, because of the divide that we saw in the Supreme Court, and also because primarily I had been saying that it is a wake-up call for the Supreme Court. The public perception of the institution was at stake, which we have gotten back today, because the Practice and Procedure Act primarily related to two things. One, it was curtailing the powers of the Chief Justice, and two, it was on the face of it, although I don't agree with it, on the face of it, it was regulating the powers or diluting the powers of the Supreme Court when exercising 1843. We saw the Honorable Chief Justice acted selflessly, and throughout he had maintained that why should one man, which includes himself, why should he have those powers? So he fought for it, that he should not have those powers. A Chief Justice should not have those powers. Similarly, we saw that today the verdict of the Supreme Court is that the Supreme Court has said eventually that collectively we should not have that much power. In 1843, there should be an appeal, because you see, previously 1843 has been subjected to misuse. So many parliamentarians have gone back home in a matter of weeks, and so many people have suffered from the exercise of such power. So today, the Supreme Court has decided that we should not have so much power. Now, this, if a Pakistani institution can maintain that we are not supreme, it's not a question of Parliament being supreme or the Supreme Court being supreme. It's a question of constitution being supreme. So I, for one, I am very happy that this decision will bring back the public confidence that was previously lost in the Supreme Court. And
Right.
and and
Yes.
and to your other question, very quickly, as to whether or not this would be misused by the Parliament, tomorrow, if it is misused, as and when the Supreme Court will strike it down. This is this is one such instance where I don't feel, and the Supreme Court also doesn't feel, that their independence has been impaired. Tomorrow, if the Parliament were so ill-advised that they were to pass another law, and if that law indeed violated independence of judiciary, then such law would be struck down by the Supreme Court. So let us not worry about future situations. Let us enjoy what we've achieved today.
All right, and Farrukh, I'd also like to take a look at the role of the Parliament, in your opinion as well. But add to that what we've spoken earlier about the way that one person is able to impact certain decisions, and the Chief Justice of Pakistan is being lauded for his courage, for being able to take a decision that curtails his own powers in a very unprecedented manner that it has been taken in a very unprecedented move. So when we talk about what the Supreme Court has decided today, in large part, is this due to the Chief Justice?
Right, Sana, thank you very much. I think that when you are going to give khatat, let us be open-minded and open-hearted and give khatat to the entire bench, because there were two or three things which were quite relevant this time. One, the full bench that was hearing it. The second aspect is that it was an open, live broadcast, hearing. So I think that all the honorable judges deserve praise because they have actually diligently put in an effort to crystallize the matter. Now, the issue of Parliament, actually, that you just mentioned, and the possibility of abuse of power by the Parliament, that is an open question, and it needs to be addressed. Now, the only thing that you have to understand is you have to appreciate nuances in verdicts. There are verdicts, then there are precedents, and then there are super precedents, right? Verdicts are merely about one case. They are particularly relevant in one case, and that is the case here as well. Then precedents which actually stay and are actually emulated as examples. And super, precedents are meant for actually when they stay for quite some time as a precedent and they are not changed, then they become example and they are usually not changed. This is how the things happen all over the world. So I think that we have this habit of actually confusing one with the other. Today's case essentially is focused on two matters which are important. One, in the absence of a defined structure, can the power be abused or misused within the judiciary itself? And because there is concentration of power and it is the final court of appeal, should there be a further appeal when it comes to original jurisdiction or not? I think that these matters were navigated very effectively by the Supreme Court, and it was particular to this issue alone. It doesn't define the limits of Parliament or limits of Supreme Court. That is an ongoing debate that we are going to have in coming days as well, because as I pointed out, trichotomy of power is something which is very crucial, and one still has to actually look at it from an unbiased position. But given that the Parliament is the only body, only institution that has direct representation of people of Pakistan, one hopes that that power will not be abused, right? Now, let us also look at what was beautiful in today's verdict. We have seen some very strange kind of tribalism that was there during the previous Chief Justice's time. At that time, it seemed that people are being eliminated from the benches the moment they started to disagree. And at that time, it became quite apparent that the then Honorable Chief Justice actually preferred certain of his colleagues over others, and that was a problem, right? Ergo, the abuse of power or some kind of misuse of power, misapplication of law. And there was a very interesting trigger in that case also, and that was Punjab's election case, where a High Court was still hearing the case when the Honorable Supreme Court decided in its infinite wisdom to appropriate that case and make it an issue of original jurisdiction, and that actually created a lot of bad blood. And because of that, I think this law was actually conceived and presented as well. So today, the beautiful thing was that it wasn't tribalism at play. The main verdict is 10 versus 5. Of course, there are judges who have given their verdict or their mind before as well, so it was to be expected. But then came the issue of appeal, and there we saw numbers changing, 9 versus 6. And then amazingly, when it came to retrospective application of appeals, and that is a very important issue as well. Yeah. There we actually saw that numbers changed so much that actually the quantum of verdict changed, right? And that was for good, that was something that was good, because there is such a thing as statute of limitation. And I think that you cannot go on infinite crusade, and there has to be a cutoff date. And if you would have actually drawn a cutoff date around one politician or the other, then there would have been an impression of favoritism. And in the end, you have to remember, Sana, that we already have 56,000 cases in pendency. So with that kind of a situation, I think that the verdict is exceptionally beautiful. The great thing is that tribalism is gone. And I think because it was broadcast live and because people kept on listening to honorable justices and the lawyers, it has actually further enhanced or resumed the integrity and stature of the Supreme Court of Pakistan in the eyes of all the citizens of the country.
Right. Barrister Yasser, I want to also explore the issue of the right of appeal, as Farrukh was pointing out regarding the retrospective right of appeal and the usage of a cutoff date. I understand that, of course, that at a certain point needs to be established, but in matters of constitutional importance in terms of many other matters that were being hoped for by different political parties and different elements for them to be able to appeal to them, and others that may have impacted the political or constitutional matters of the country to a very significant length. I want to then understand what you think about this opinion, this particular decision in that sense, whether when we talk about and when we celebrate this decision now, should it not have also applied to matters that are still being impacted today because of the decisions taken earlier?
I certainly believe so, and I think the 8-7 division in the Supreme Court, I would have liked, and that's just my personal opinion, I would have liked it to go the other way, where they appeal the right for retrospective appeal under 5(2) of the law should have been upheld, because there are certain cases, certain judgments that have come out, and this is only because of that. I completely agree with the fact that there should be a cutoff date and there should be a statute of limitations, as it were. However, the fact of the matter is, much of what we are seeing right now, there are certain cases in our history which have created insoluble problems.
Can you identify them? So
for example, just one major example is and I'm not taking any parties. I'm not on any party's side, but I believe the Panama judgment, or the Ikama judgment as it were, was a travesty of justice. I think that shouldn't have happened. I think 184(3) should not have been used to disqualify people, especially a former Prime Minister, and I think that itself needed to be revisited. However, I understand that if that had been the case, one would have argued that this was a person-specific law.
But I can give you another example. When vote of no confidence was taking place in the Parliament, at that time also it was Supreme Court that intervened. Do you think that would have also been revised?
Well, in that case, it was a blatant exercise. So we're not against the Supreme Court going ahead and striking down those laws or executive actions that go against.
We are talking about right of appeal.
The right of appeal, yes. I believe that the right of appeal should exist, and it should exist for. This is just my view. Of course, the Supreme Court has now held that there can be a retrospective right of appeal. Again, some of the people who were the supporters, so it's a very divided verdict if you think about it. It's 8-7 still, and there are very, very good jurists and legal minds who've decided that no, the retrospective right to appeal could exist under the Constitution. So that's not something that is, was a unanimous decision in that sense. I believe that it would have been better if we could go back and revisit some of those ugly judgments in our history. I would call them ugly. I think that would have been best, but I understand this is how the verdict would have come anyway. And I think one of the judges who had voted to uphold the law ultimately turned and said, this is where I draw the line. So fine, that's what the Supreme Court's prerogative is.
Right. Barrister Yasser, I want to understand something, and excuse my ignorance, but I want to understand whether the appeal that is now being given, of course, on certain matters will possibly come into conflict with certain matters which now don't have the right of appeal. Will there be cases that will be based upon previous cases that don't have the right of appeal? But if you're appealing a certain case at the moment, how will then these two work together?
Well, I believe the principle of pass and close transactions has come into play, and that will be sort of going forward, that is going to be the case. I think that many of those judgments will now not become necessarily, or they would be, let's put it this way, there would be now an opportunity to revisit those verdicts in a different way, right? In a different case, you hold something completely different under 184(3) in an appeal. Suppose there's an appeal against a certain case. I think one of the cases that is definitely going to come up, I think the issue of elections itself, the elections judgment, that is going to be something that's going to come up. I think the NAB amendments, that might be something that might come up. But ultimately what it does, and I think what we have to look at and we have to celebrate today is the triumph of principle. The principle is that the Article 10A of the Pakistani Constitution gives everyone the right to fair trial and due process. And there couldn't be fair trial and due process if you're not going to subject this particular original jurisdiction, original constitutional jurisdiction of the Supreme Court to a right of appeal, because we've seen how this has been abused in the past. I think in that sense, what we see today is not just that the right of appeal has been upheld, but one other thing that's not as, it's not been mentioned as much, is the fact that the right to change your counsel in review or in appeal has now been given, which was not the case earlier. And I think that is very important. I mean, you couldn't, after you'd taken a decision to hire a counsel, you couldn't change that counsel later on, and that was a major issue for a lot of litigants. And it, you can imagine, say, a person is completely dissatisfied with their counsel, and they should have the right under Article 10A to change their counsel. So that's something that's been upheld. So overall, what we've seen is that the collective wisdom of the people, of the nation, of the polity, as it were, has triumphed in that sense, and that is what the Supreme Court under this Chief Justice, who's a Democrat par excellence, has basically, that has been upheld, that collective wisdom, and that is what we must celebrate today.
Right. Barrister Shabbir, I'd also like your opinion with reference to the right of appeal, and add to that the specific case of Mr. Nawaz Sharif also, not just in terms of course, the fact that he won't be able to appeal his case, but also in terms of now his disqualification and the constitutional amendment that limits that to a 5-year time period, but is in contradiction with an earlier Supreme Court judgment. And I want to then understand, given the fact that he is not able to appeal previously, how will then this entire case be impacted?
Okay, first of all, let me just give you my 2 cents on retrospective element. I think, in my humble opinion, I completely agree with the judgment of the Supreme Court. The retrospective element, which has been struck down by the Supreme Court, is perfectly fine, because you see, we need to see this in not just one context of Mia Nawaz Sharif's case or a single disqualification, but assume, in fact, there have been judgments. For example, there was a judgment in respect of service laws where hundreds, rather thousands of out of turn promotions in police and in other departments on political considerations were were turned down by the Honorable Supreme Court, exercising power under 184.3. Now, once that was turned down, others were promoted in return, or others who took benefit of that judgment. Now, today, if we allow retrospectivity, then those people for whom the Supreme Court judgments had become past and closed transactions, their beneficial rights will be disturbed. So, whenever you are interpreting a law, you are not interpreting it in the context of one given situation. You have to take into consideration so many situations. So, and when the reasons will come, I am sure you will see. In fact, I would like to compliment Honorable Justice Muhammad Ali Mazhar, to name one. There were other judges also, but he was leading this line of questioning that retrospectivity he would not allow. And I for one, believe that this is a good judgment, and it's perfectly all right that the section which pertained to retrospectivity has been struck down. Now, moving on to Mia Nawaz Sharif's case, I had previously also opined. I don't think that Practice and Procedure Act specifically, Mia Nawaz Sharif is dependent on this, because he was disqualified after through the Panama judgment, and then in Samiullah Baloch's case, it was decided by the Honorable Supreme Court. The judgment was authored by Honorable Justice Umar Ata Bandial Saab, and the ratio was that once you are disqualified, you are permanently disqualified. But also in that judgment, it was said that this judgment applies to those cases where you've had an opportunity of fair hearing. So I don't think Samiullah Baloch judgment applies to decisions which were given in 184.3. That is my opinion, number one. Number two, Section 232 of the Elections Act, which holds the field, specifically states that all those disqualifications provided in the Constitution, where the time period is not mentioned, the time period will be 5 years from the date of disqualification. So in Nawaz Sharif's case, 5 years have elapsed. I don't see how he's disqualified or he's affected by the earlier judgments, because when the judgments were passed, this new law was not taken into consideration. So I think he has a green light. He can still contest elections, subject to one caveat though, which is that Article 63H, 62(1)H provides that if you are convicted by a court of competent jurisdiction, once you've served your sentence, after a period of 5 years from the date when you've served your sentence, then you can contest. So in his case, I don't think he served his sentence. He would have to serve his sentence unless the sentence is suspended. So he can just get a bail once he arrives, and he can, maybe if his sentence is suspended, he can contest elections. He has green light.
All right. And Barrister Yasser, I also take your opinion on this in terms of the legalities that Mr. Nawaz Sharif will be facing upon his return. But Farrukh, before I do that and we move on to the next segment, I also want to explore when we talk about how unprecedented this case has been and the way that it has been handled. I want to then know whether there will be the side effect of a certain expectation from the judiciary to be able to carry out future cases of such importance in a similar way.
Right, Sanam. I think that earlier question, your earlier question to me was a beautiful question, and I missed the mark as well when you asked me regarding Chief Justice's contended in the whole thing. I think that in Pakistan's history, there have been only one similar instance when somebody has actually voluntarily given up their power. That is Asif Ali Zardari when he was president. After that, it didn't happen, right? Pakistan is notorious in such a way that if something bad happens under your watch, you seldom tender resignation, and if you have power, you never give it up. So it is a good tradition, and I think that we all should be lauding the Chief Justice of Pakistan. It is only providing a structure to the suo motu powers or original jurisdiction cases, that there are going to be three pair of eyes that will be looking at the matter, not a single pair of eyes, and that is good news for the country. Now, regarding this question, can you repeat it very quickly?
My question was that in the manner in which this particular decision
Yeah,
was taken.
thank you. I just needed one word trigger. So the overall, the way it was actually live streamed, and then of course it had the entire bench sitting and hearing it. I think that is something that might not be necessary in all cases. Especially when it comes to individual cases, relating to individuals. But when it comes to legal or constitutional matters, I think it will be prudent to uphold these examples, especially when it comes to live streaming, because particularly, so one of very important role of Supreme Court is to actually decide between federating units if there is a conflict that arises. So it will be important that such important cases are heard on live television so that people can understand what is going on in the country and both sides are satisfied. This time also, by the way, when you listen to the commentators, there are people who are going to be extremely tribal and who are going to be extremely factless. I cannot comment on them, but I have heard the people who in the know from both sides of the divide who are actually lauding this verdict. So I think that with this kind of openness, people like them can be won over very easily, and it enhances the role of Supreme Court. Right. But whether it is possible to make it a routine, I don't know. We'll have to wait and see.
My question, Farrukh, was in light of how we have seen previously that this demand of forming a full court bench seems to be coming from different quarters on perhaps numerous cases where it might even be unnecessary. So will that expectation increase and that demand increase?
Yeah, one case where we kept on hearing the demand was regarding election date, right? And I think that that is an important thing. Recently, we once again heard the echoes of talk of a grand national dialogue. So the interesting thing is that one part of the dialogue, that is Parliament, is half empty. That is the National Assembly. So I think that in that case also it will be prudent to have the entire bench, but I don't know what actually becomes of it. My concern regarding what you were talking about earlier regarding Mian Nawaz Sharif is that back in 1980s we used to hear that General Zia's name was included inside the Constitution of Pakistan to give him exemption. So it really worries me when an entire system bend over backwards to punish somebody or to provide one individual relief, right? When Mian Nawaz Sharif was targeted, that was unfortunate. It seemed the entire system is manipulating itself to do it. Now also, if the example becomes that he is being provided exceptional relief through the entire system's contortion, that becomes a worry. So I'm glad that the Supreme Court of Pakistan has given a verdict worth its own stature, and that is imposing stature.
Right. Barrister Shabbir, my last question to you is regarding something you talked about earlier with reference to how we look at it in the future in terms of how the Parliament is going to be performing, or whether or not there is going to be an abuse of power. And the Chief Justice has also talked about good intentions and how institutions will be able to enhance the role of each other. But I want to then understand that when we talk about accountability and the fact that an elected institution it needs to be in place, and the judiciary or others will be accountable to that. I want to then understand that if in certain cases the Supreme Court will be able to strike down whatever decisions it is of the Parliament, and vice versa perhaps, but how exactly will this system of accountability then be able to function in a way in which we don't have elements that are spoilers, or elements that are there to exert pressure on different institutions, where what we need is increased accountability of all institutions, but what we get may be something completely different, where that is not achieved, and in fact there is unnecessary friction. Do you think that's a possibility?
You see, this decision has in fact strengthened what is the basic feature of our constitution, and that is separation of powers. Each institution should be independent in their own right. Unfortunately, in the past 10 or 12 years, the Supreme Court has been exercising this power under 184(3), whereby so many parliamentarians were sent back home. So in a hearing of 5 minutes, the decision would come that you were not honest, you were non profligate, you were dishonest, not righteous, and not sagacious. Because you forgot to mention one bank account, because you forgot to mention one property, and out you go, notwithstanding your people's vote. Every parliamentarian would, would fear for the security of their tenure. Now, what has happened is that today we don't have the same power of 184(3). Even if a bench of the Supreme Court takes up an issue under 184(3), the parliamentarians, the people of Pakistan, would be sure that fine, if one portion of the Supreme Court or one bench presumably is biased, the right of appeal exists. So the powers which were previously misused, now there is a check and balance. So I think the parliament
Okay.
has been strengthened on account of this law, which has been upheld by the Supreme Court. Number one. Number two, simultaneously, if the parliament were to completely act in a manner which is in violation of the constitution, there are always two checks, and the biggest check, let us not forget, is the people of Pakistan. I mean, tomorrow, if the parliament were to pass an absurd law, they will never be voted again. So the people of Pakistan should have that power. And at this point in time, this power ultimately should vest in the parliament to decide what is right for the people. Because previously, if the ultimate power vests with the Supreme Court, you have seen that the judges are not elected and they are not answerable to the people. If one judge or the other judge, after their retirement, they are not answerable to the people. So therefore the constitution has thought it best that the people of Pakistan should decide what is best for them, because tomorrow they are going to go back to the people of Pakistan and they will then decide to outvote them. And at the same time, if any other law is passed by the parliament which is in violation of the constitution, the Supreme Court, but even the High Court can strike down that by setting aside that law. So I think we are in a fairly comfortable situation, far better than before.
Yeah.
All right. Thank you very much, Barrister Shabbir Machar, for joining us and being a part of the discussion. Barrister Yasser, earlier we were talking about Mr. Nawaz Sharif and the legalities that he's going to be facing, and I want to explore that further in terms of what the party has been saying is that he's not going to shy away from any legal matters that are due, and that he will face the courts. And I want to then understand whether the situation is as simple as what Barrister Shabbir earlier was pointing out in terms of a green light for him to participate in elections, or do you think it's more nuanced?
I think as far as now, here we have to also look at realpolitik, because in terms of sort of the jostling of power between different institutions, I think there's a sword of Damocles that's hanging on the head of Mia Nawaz Sharif in terms of some of the things that are there in his past, right? I mean, we're talking about the outstanding cases, etc., the sentence that is, whether it is suspended or not as yet, what's going to happen once he lands, will he get a bail, will he apply for a bail? Remember, he had left the country after a guarantee that was given on a stamp paper, and all of that is there. Now the question is, what happens when he comes back? I completely agree with what Barrister Shabbir was saying in terms of what he said about the green light being there after the Election Act amendments. I think that is the case. But in terms of what he's going to do once he gets back, I think that's where the jostling of powers between different institutions are going to play. I don't think anybody has been given a blank check. The powers that be would want everyone to stay within their own lane, and I think that's what's going to happen with Nawaz Sharif as well. This is something that that's going to be hanging over his head for the rest of the for till the elections and so on and so forth.
Right. And so regarding his disqualification time period, do you think that won't be a problem in the court?
I believe that would, as far as there being after the Election Act amendments, I think that is a issue that has been resolved.
Okay.
I believe that we would have to see how that is interpreted, whether the disqualification period was, since it is 5 years, when did it start, when was it running, and has that period now elapsed? All of those things. But I agree with what Barrister Saab was saying. I think that is definitely something that is going in his favor right now. There's definitely a green light for Nawaz Sharif to contest the next elections and perhaps come back to power, as it were.
All right. Farrukh, when we take a look at what the party is planning, of course, they are expecting the return of their leader in a matter of days, and there seems to be a lot of talk going on for quite some time now of how different the situation will be politically for both the party and for the country when he returns, and his contribution to the political domain will change everything. In light of what our legal experts have also spoken about in terms of the role that he will be able to play in the political domain, it seems that it can be very active and that he will be able to participate or contest in the elections as well. How then do you think that his return is going to affect this current dynamic?
Right. There's a lot to unpack here. I hope that I can do it in remaining time. Very quickly, Sana, there are 2 or 3 things. That first, let me state my principle. I'm a libertarian, so I believe in minimum number of filters. 62.3 and 63 are essentially filters to keep people out of the parliament, right? I believe in minimal filters possible to keep people out, because it is people's right to vote whosoever they want. And I understand that in past, law and system, as I was mentioning earlier, was distorted to victimize certain people or to actually provide relief to certain people, and that continues. But as things stand today, Mia Nawaz Sharif is an unprecedented case of a convict on medical leave. So he is abroad on medical leave, but he belongs in the prison, right? And there is I don't know how can he get any kind of bail when he returns, because I don't think you get a bail for after conviction, right? But having said that, I don't understand this hesitation on the part of politicians to stay out of prison. This country was created by the and India and Pakistan both got their freedoms because of the struggles of very important politicians who chose to actually go behind bars, and that was how they actually increased their stature. So whether it is Mian Nawaz Sharif, whether it is Imran Khan, or whose supporters caused May 9th just because he was apprehended, I don't understand this hesitation. As far as playing a role in political situation is concerned, you can very comfortably sit behind bars and actually change the whole narrative. Because if you actually come back and voluntarily go behind bars, and of course then there is litigation and he can get some relief as well, that decision can be overturned, especially his being behind bars. So if that happens, he can very comfortably do whatever he likes. But right now, I think this hesitation on the part of politicians doesn't seem to actually serve them well. Regarding overall atmospherics, we still have to wait and see this idea. We kept on, for years and years, we kept on contending PTI's this statement or this notion that if they collect too many people to their jalsas, then they are the most popular party. And this seems to be the strategy of PMLN now, who used to object to that Mian Nawaz Sharif comes and he is going to speak to huge crowd, and that crowd will essentially actually define how popular he is. So I think that we, instead of actually bending the whole logic or whole system, I think we have to wait and let people decide who is popular, and he can very effectively influence the atmospherics if he actually plays his cards smartly.
Sure. Thank you very much, Farrukh, and thank you very much, Barrister Yasser, for joining us and being part of the discussion. That's all that we have from the debate.